Hey, Douglas, we got 4 people, so we can go ahead and get started.
Okay. All right, great. Okay. The August 31st, 2021 meeting of the Charlotte Zoning Board of Adjustment is now in session. I am Douglas Wilson, Chairman. Also sitting on today's board is Deborah Dryden, John Floyd, Raghu Kratha, Marsha Williamson, and John Floyd. And I believe Max Christy Long is also here as well. Also present are Chad Spencer, Zoning Board Administrator, Lisa McCarter, Planning Project Manager, Terry Hagler Gray, Senior Assistant City Attorney, Jill Sanchez Myers, Senior Assistant City Attorney, Max Oliver, Clerk to the Board, and Atkins, Court Reporting, Verbatim Reporter. I would like to start by acknowledging that we are conducting this meeting using a remote electronic platform. This is the 15th remote meeting of the Charlotte Zoning Board of Adjustment, and I'd like to ask for your patience today as we proceed. There may be slight delays as we transition between speakers, participants, and presentations. The Zoning Board of Adjustment is a quasi-judicial board that is governed by the North Carolina General Statute and the Charlotte Zoning Ordinance. We conduct inventory hearings on requests for variance and appeals, among other requests. Before we begin to hear the cases on today's agenda, I'd like to provide some important information on the steps that were taken to ensure that such parties' due process rights are protected as we proceed in this remote platform. First, today's meeting will be conducted in accordance with special legislation passed by the North Carolina General Assembly in Session Law 2020-3 that allow for remote meetings and quasi-judicial hearings during declarations of emergency. Second, each applicant was notified before being placed on today's agenda that this meeting will be conducted using a remote electronic platform. Every applicant on today's agenda has provided signed consent to the board prior to conducting the evidentiary hearing on their requests using this remote platform. Third, notice of this meeting was provided to the applicants and the public in several ways. Notice of today's hearing was mailed to property owners within 300 feet of each subject property and notified the property owners of the remote electronic platform, and the letters also stated to contact the city immediately if there were any objections being heard of today's agenda. Notice was also provided by placing signs on each property and by publishing notice on the city's website. The notices for today's meeting contain information about means by which the public can access today's proceeding. And finally, any individual wishing to participate in today's evidentiary hearings were required to sign up prior to today's proceedings. This information was also included on the board's website. Hearing. Applications for a variance for the regulations in the zoning accordance. Application for a variance from the regulation zoning ordinance. The order of recommendation agenda will be as follows. The zoning board administrator or zoning staff member will identify the case and recommended approval of the variance within any recommended conditions based on specific reasons. The chairperson will ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard at a later date. The chairperson will ask if the board has questions, staff, or if there is any reason the board wishes to move the case to the regular agenda. The chairperson calls for a motion and the second to approve the variance. The chairperson will hold a roll call vote. The order of agenda will be as follows. All parties who plan to give testimony, pro or con, must be sworn in. A zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member and then the applicant may question the staff member. The applicant presents their testimony for this case. The board may question the applicant and the staff member may question the applicant. The applicant may present sworn witnesses. They will be subject to questioning. Other parties wishing to speak, pro or con, will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each regular agenda case. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. All exhibits must remain with the board. Exhibits were required to be provided to the clerk no later than 12 p.m. on Monday, August 30th, in order to be considered at this hearing. If your case is not appealed to the Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it be known at the start of your case. The board is acting in a quasi-judicial capacity for the purpose of this hearing and can only accept sworn testimony. While the board will not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar has issued an advisory opinion that if the unauthorized practice of law for an individual who is not an active member of the bar to appeal for another or otherwise assist or represent another at a quasi-judicial hearings on zonings and land use matters, all applicants should have been provided with a copy of that advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of that opinion, please use the WebEx platform function to message the clerk. The documents will be provided to you. If, as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such a request at the start of that case. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to apply in accordance with North Carolina General Statute 160A-388E as in Edward. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filed with the board clerks or chairperson at the time of the hearing of the case. Please remember to mute your microphone when you do not intend to speak. You will hear 4 cases today, 3 recommended agenda items, and 1 regular agenda item. Today's first case is case number 2021-075, 2217 Crescent Avenue, presented by Lisa McCarter. Clerk to the board will read the names of anyone who opposes this case. Lisa, ready to present?
All right, our first case is a residential street side yard variance request. The applicant is requesting a 5-foot variance from the required 10-foot street side yard to allow addition to the principal structure, and I'll give you a minute to look over your findings.
Okay, Lisa, you can proceed.
Exhibit 1 is a vicinity map of the property. Exhibit 2 is a zoning map of the property. The zoning is R5 single family.
Excuse me, Mr. Chair. This is Jill Sanchez Myers, counsel for the board. Have the witnesses been sworn? I apologize if I missed that.
No, it hasn't. I thought that we had to wait till after the presentation, but Max or Lisa, is there anybody in attendance that's going to speak in opposition to this case or for this case?
Or at least for Lisa to be sworn before beginning. That'd be great.
Okay.
Thanks.
Okay. I'm sorry, Max. I don't know if you responded. I'm sorry. I thought I heard you in the background.
No one has opposed this case, and it's on
Okay.
the recommendation agenda. So if anyone needs to speak from the applicant side, they can be sworn in after.
Okay. All right. Thank you, Jill. Okay, Lisa, you may proceed.
All right. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property. And exhibit number 5 is background. The subject property was subdivided in 1909, and Mecklenburg County tax records indicate that the home on the property was constructed in 1942. Slide 6 is the variance request. The property is a corner lot and the street side yard is adjacent to Cook Street. The R5 zoning district requires a 10-foot street side yard, and there's a non-conforming established street side yard of 5 feet from the original home construction, and that predates the ordinance requirements. The applicant wishes to renovate the second story of the home and add an addition to the rear of the home using the established 5-foot street side yard. All new construction on the home is subject to today's ordinance requirements, so the applicants are requesting a 5-foot variance from the 10-foot side yard for the additions. Exhibit 7 is considerations. Staff supports the requested variance. The hardship does not result from actions taken by the applicants. The home is a non-conforming structure with an established street side yard of 5 feet, and the requested variance will not exceed the existing encroachment. The hardship results from conditions peculiar to the property. The subject lot is a corner lot, which requires a greater side yard dimension than a typical lot. Granting the variance will not alter the essential character of the neighborhood. The adjacent home across Cook Street, which you can see in the bottom left, also appears to have an established side yard of approximately 5 feet in aerial photography. Granting the variance will allow the renovations and addition to be visibly integrated with the existing home and roof line. The proposed elevation from Crescent Avenue is on the bottom right of the screen. Exhibit 8 is considerations. This is the Cook Street elevation showing how the roof line and side of the home will be integrated with the existing structure. And exhibit number 9 is photos. And there's a photo of the front of the property on the left side of the screen. And then the addition will not adversely affect adjacent or contiguous properties. To the right, you can see existing vegetation and trees that will serve to screen the proposed addition. And that's the end of my presentation, and I'd be happy to answer any questions you have.
Okay, thanks, Lisa. Does anybody have any questions for staff? Okay. And Max, I heard you correctly, so we don't have anybody to speak in opposition or for this case, right? So we don't have anybody.
That's correct. No members of the public have signed up to speak in opposition nor in favor of the case.
Okay. All right, great. All right. So if there are no questions for staff, we'll move to a vote. Is there a motion to approve the variance?
This is John Floyd. Move to approve the variance.
Okay. The motion's been moved and properly second. Now we move into a period of vote. All those in favor, please respond by saying aye.
Marshall Williamson, aye.
Okay.
Crystal Long, aye.
Right.
John Floyd, yes.
Okay. Is Mrs. Dryden on?
I see a note from her in the chat.
I swear it's not showing up on my end. It's weird. Okay. What is her note in the chat, John? For some reason, I don't see it.
Apparently she's having issues hearing. She said
Okay.
she could see the presentation, but
All right.
I'm sorry, I don't think I caught a second for that motion.
Yeah, the second was by John Floyd.
Oh, thank you.
Sorry about that.
Mr. Chair, her message says that she could see the presentation, but she has no sound. So if she was not able to fully participate in that case, I would just recommend that she not vote on this particular matter until she can hear everything presented. Thanks.
Okay, would that affect this case at all, going one way or the other?
You would still have 4 members voting.
Okay.
So you still have,
All right,
yeah,
great.
that's fine.
Okay. All right. And Wilson, I vote yes. Okay. All right. The variance has passed. Now move into the findings and facts of the law. Does anybody see anything that we need to change? I didn't see anything. Okay. All right. If there's no changes to the findings and facts of law, is there a motion to approve?
I'll make a motion to approve. This is Long. The findings of fact to law.
second by John Floyd.
Okay, motion's been approved and seconded by motion is moved by Christy Long, and it was seconded by John Floyd. Okay, now we're going to a vote. Mrs. Long?
Long, yes.
Okay. Mr. Floyd?
Floyd, yes.
All right, Mr. Williamson?
Williamson, yes.
Okay, and Wilson, yes. Okay. Okay, the next case is case number 2021-077. It is located at 221 Ledgewood Lane. Lisa?
Let's go ahead and get myself and Lisa sworn in for this one in case there's any questions.
Sure thing.
Thanks.
Okay. And that sounded like Mr. Murray, am I correct? Or not Shad, sorry, Shad, okay.
Yeah,
Thank
yeah,
you,
I'm sorry, that's me, Shad.
Okay, you and David kind of sounded like.
Mr.
All right.
Wilson, I was just saying that I stipulated, just for the purposes of the record, I wanted to make sure that I stipulated to 4 members on that first vote, just so we're clear, we stipulate to 4 members on that first case. So just to clear up the
Okay.
record. Thank you.
Okay, thank you very much. Okay, great.
Oh.
Okay, so, so Shad, you were saying that I'll have to swear you and Lisa in?
Yes, please.
Okay, all right. All right, Shad and Lisa, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
I do.
Okay, all right, let's start with the presentation.
All right, our next case is a residential rear and side yard variance request. The applicant is requesting 2 variances to allow for a second-story addition to the principal structure. This is a 23-foot variance from the required 35-foot rear yard and a 2.8-foot variance from the required 5-foot side yard. And I'll give you a minute to look at your findings if you just let me know when you've had enough time.
Okay, Lisa, you may proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The property is zoned R5 single family, and it's in the Dilworth Historic District overlay. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The property was subdivided on an undated subdivision plat, and the home on the property was constructed in 1934, which predates ordinance requirements. Exhibit number 6 is the variance requests. There's a required 35-foot rear yard and a 5-foot side yard in the R5 district. The existing home is non-conforming and has an established 12-foot rear yard and a 2-foot side yard. The applicant wishes to add a second-story addition to the home using the existing 12-foot rear and 2-foot side yard. They're requesting a variance of 23 feet from the required 35-foot rear yard and 2.8 feet from the required 5-foot side yard. There's other variances requested on the application, but according to the applicant's plans, the proposed addition will be in compliance with other ordinance regulations, so those aren't necessary. Exhibit number 7 is considerations. Staff supports the requested variance, and the hardship does not result from actions taken by the applicants. The home was built in 1934 prior to any zoning regulations. Granting the variance will not alter the essential character of the neighborhood because the encroachment is not easy to detect. The proposed addition will be visibly integrated with the existing home and will not expand beyond the established side and rear yards of the home. Also, other properties in the area have added second-story additions. The adjacent homes are 2 stories, as you can see in the bottom right of the screen. Slide 8 is further considerations. The hardships result from conditions peculiar to the property. The side of the property is angled and narrows to the rear, and the rear property line is also angled, which results in a smaller building envelope and rear yard. The lot is visibly smaller compared to most other lots in the area, and the 97-foot depth of the lot is less than most of the surrounding lots. Exhibit number 9 is more considerations. The property is located in the Dilworth Historic District overlay. The HDC staff has met with the project architect and property owner and indicated this case is typical of project requests submitted to the HDC. After receiving a determination from the ZBA, this project will be reviewed in its entirety by the HDC for compliance with the design guidelines. And here you can see the proposed front elevation and the proposed left side elevation. Exhibit number 10 is a photo of the property. And that's the end of my questions, and I'd be happy to answer any questions if you have them.
Okay, thank you, Lisa. Max, is there anybody wishing to speak in opposition or for this case?
No, no one has signed up to speak about this case.
Okay, great. Does anybody on the board have questions for staff? Okay, if not, I'll like to move this to a vote. Is there a motion on the floor?
Motion to approve.
Sorry, I didn't hear you.
Sorry,
Sorry.
Williamson, motion to approve this.
Okay, there's been a motion moved by Mr. Williams. Is there a second?
Second, John Floyd.
Okay, motion's been moved by Mr. Williamson, second by Mr. Floyd. Now we're moving to a period of voting. Mr. Dryden,
Dryden, yes.
okay. Ms. Long,
Long, yes.
okay.
Williamson.
Mr. Williamson,
Williamson, yes.
okay. Mr. Floyd,
Floyd, yes.
okay. And Wilson, yes. Okay. Now we move to the finding of facts of law. Is there a motion to approve the findings and facts of law?
Williamson, motion to approve.
Okay, there's been a motion moved by Mr. Williamson. Is there a second?
Second by Floyd.
Okay, motion's been moved by Mr. Williamson and second by Mr. Floyd. Now move to a roll call vote. Mr. Floyd,
Floyd, yes.
Mr. Williamson,
Williamson, yes.
Ms. Long,
Long, yes.
Ms. Dryden,
Dryden, yes.
and Wilson, yes. Okay. All right, our next case will be case number 2021-079, located at 754 Ideal Way. Lisa, you may proceed.
All right, our next request is a residential setback, rear yard, and lot area variance. And the applicant is requesting 3 variances for a previously recorded single-family lot to allow it to be reestablished and used for a single-family dwelling. And I'll give you a moment to look over your findings, and you could just let me know when you've had enough time.
Before we proceed, Mrs. Sanchez Myers, I know in the first case you mentioned that we should swear in anybody who may be in opposition of the case or for the case in the beginning of the presentation. Should we, I just remembered in the past, we usually do that after the presentation is done. Should we do that going forward, like just to have folks sworn in before Lisa gives her presentation?
So, Mr. Chair, yeah, I think it's best to swear in any witnesses at the beginning. So particularly Lisa and Shad, because they will be presenting usually first. Lisa is usually first, but any other witnesses that are there to speak can be sworn in at the same time. If they are on the line, they may not join until later, or, you know, it would be fine to swear them, the applicant or speakers, in prior or at the presentation of their particular case. But today I was just wanted to at least point out for Lisa and Shad and anyone on the first case, to just go ahead and get that out of the way was all.
Okay, but Lisa and Shad, they do not have to be sworn in for every single case.
Once they're sworn in, then, you know, that they're
Gotcha.
good
Okay.
through the meeting. Yeah, but it's good to just get them sworn first. And then on each particular case, if there are any additional witnesses who will be presenting testimony, go ahead and get them sworn. But that could be done at the beginning of the, you know, their presentation or their statements that they would like to make as well.
Okay. Got it. Okay. Thanks for that clarity. Just want to make sure. Okay, Lisa, you may proceed.
Exhibit number 1 is a vicinity map of the subject property. Exhibit number 2 is a zoning map. The zoning is R5 single family. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The zoning ordinance permits previously recorded lots to be reestablished if the lots have never been legally combined, and the reestablished lots will meet the standards of the R5 zoning district. The subject property is still described as 2 lots, lots 1A and 1, and has never been legally combined. The applicant wishes to reestablish lot 1A as its own lot. Once reestablished, lot 1A will meet the definition of a non-conforming vacant lot. Exhibit number 6 is more background. The zoning ordinance requires the lots to be reconfigured so that lot 1A would meet the minimum lot size of 6,000 square feet for the R5 zoning district. Applying the zoning ordinance setback and rear yard to lot 1A creates an insufficient permitted building footprint to construct a home. So you can see over in the graphic, the little pink triangle area is the allowed building footprint, and lot 1A is 5,676 square feet and not the 6,000 required. Government exhibit number 7 is the variance requests. The applicant is requesting 3 variances to allow for the subsequent reestablishment of lot 1A for a single-family home site. A 324 square foot variance from the 6,000 square foot minimum lot size, a 10-foot variance from the setback, and a 25-foot variance from the rear yard. This would permit a 10-foot setback and rear yard and give them the building footprint you see in the pink area for lot 1A. Government exhibit number 8 is considerations. Staff supports the requested variance. The hardship results from conditions peculiar to the property because the lot of record is just short of 6,000 square feet, which is smaller in size than other 9,000 to 17,500 square foot lots in the area. The lot depth is 46 to 57 feet, and that's not sufficient to permit a single-family home without a variance. The applicant stated that they do not want to reconfigure the lots and move the lot line for lot 1A to increase the lot area because they would lose the potential use of lot 1 as an existing lot of record. The hardship did not result from actions taken by the applicant because the lots were recorded in 1948 prior to current zoning ordinance requirements. Granting the variance will not alter the essential character of the area. The subject variance would result in a 10-foot setback and a 10-foot rear yard, allowing a building depth of approximately 26 to 37 feet, and that's smaller than many of the other homes in the community. And you can see the other home depths in the lower right of the screen. The requested 10-foot setback is consistent with the R5 street side yard on the adjacent corner lot across McDonald Avenue. Granting the variance will not adversely affect adjacent or contiguous properties and is in keeping with the intent of the zoning ordinance and will uphold public safety. Exhibit 9 is photos of the property. So on the left side, you can kind of see looking back that other lot area for lot 1A. That's the end of my presentation, and you can let me know if you have any questions.
Thank you, Lisa. Max, is there anybody that wishes to speak in opposition to this case?
No, no one has signed up to speak in opposition to this case.
Okay. Does anybody on the board have any questions for staff?
This is
Okay.
Marshall Williamson. The only question I have is maybe a little bit unknown, but if we approve this, what's to say the next door neighbor wouldn't want to come to us later and request the same type subdivision of their lot? And if they did that, their lot would effectively be landlocked. And how would one access that future lot or any potential future lots? And I think there's a park behind this property. Is that correct?
That's correct. And that's a good question. The answer is that the other lots don't have that frontage that Lot 1A has on McDonald Avenue. So like you said, they would not have, there's a requirement that every lot must abut a street. And so they would not meet that requirement. So they would be looking at even further variances if they did want to reestablish. They would have to get a variance from the requirement that every lot abut a street, you be at least 2 acres and have some kind of exclusive access easement.
Okay. Are there any more questions for staff? Okay. Hearing none, is there a motion?
This is Dryden. I make a motion to approve the variance.
Okay, motion's been moved to be approved by Mrs. Dryden. Is there a second?
This is Long. I'll second.
Okay, motion's been moved and properly by Mrs. Dryden and second by Mrs. Long. Now moving to a period of voting. Mrs. Long?
Long, yes.
Okay, Mrs. Dryden?
Dryden, yes.
Mr. Floyd?
Floyd, yes.
Mr. Williamson?
Williamson, yes.
Wilson, yes. Variance is approved. Now we move into the finding of facts and conclusion of law. Is there a motion there?
This is Dryden. I make a motion to approve the finding of facts as written.
Okay, motion's been moved by Mrs. Dryden. Is there a second?
Long seconds.
Okay, motion's been seconded by Mrs. Long. Now I'm moving to a period of voting. Mrs. Long,
Long, yes.
Mr. Williamson,
Williamson, yes.
and Mrs. Dryden,
Dryden, yes.
Mr. Floyd,
Floyd, yes.
Wilson, yes. Now moving on to our agenda for our next case is case number 20221-066, located at 608 Bascom Street. Okay.
All right.
All right, Lisa, you may proceed.
Okay. Our next request is a residential accessory side yard variance. The applicant is requesting a 4.4-foot variance from the required 5-foot side yard to allow an existing accessory structure to remain. And I'll give you a minute to look at your findings, and you could just let me know when you're done.
You may continue, Lisa.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The zoning is R5, single family. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is an aerial close-up. Exhibit number 5 is the background. In 2019, a permit was issued for a 23-foot tall, 2-story garage on the property. The zoning ordinance permits a 3-foot side and rear yard for accessory structures up to 24 feet in height. However, if the accessory structure exceeds the height of the home, it's required to have a 5-foot side yard and a 15-foot rear yard. The home on the property is 16 feet in height, so a 5-foot side yard is required for the 23-foot tall garage, even though it's less than 24 feet. And due to an inadvertent error during the permitting process, staff didn't verify the height of the home, and a 3-foot side yard was indicated on the permit rather than the 5-foot side yard. Exhibit number 6 is the background. After the garage was constructed, code enforcement received a complaint about the garage. In June 2021, a notice of violation was issued because of the apparent side yard encroachments. Exhibit number 7 is the variance request. Due to the measurement of the angle of the right property line, and if you can see my pointer right here where the two sides come together, it is considered an extension of the side property, and the rear is measured from a radius from the point furthest from the right-of-way. So the rear is back here, and these are both side yards. The garage is required to be a minimum of 5 feet from both side yards. A survey of the garage shows that it is located a half a foot from the property at the closest point. The applicant is asking for a 4.4-foot variance from the 5-foot side yard to allow the garage to remain. Slide 8 is considerations. Staff finds the requested variance does not meet all of the criteria within the zoning ordinance for granting a variance. Although staff finds that a 3-foot side yard, which would be 2 foot from the required 5-foot, as was noted on the building permit, would meet the criteria for granting a variance, the requested variance for a half-foot side yard does not meet the criteria. The hardship results from actions taken by the property owner due to the closer placement to the property line, and there's no evidence of practical difficulty or unnecessary hardship. Although the property is angled in the rear, the structure could be located in compliance with the required 5-foot side yard. The applicant states that the current placement of the garage is necessary so that it can be located at the end of the driveway. There are conditions that are peculiar to the applicant's property, but they don't appear to prevent the compliant placement of the accessory structure. There are overhead power lines located in the rear yard, and you can see them, they say PL on the survey in the lower right of the screen. There's also a 5-foot utility easement that the garage is encroaching, and you can see that back here. It says 5-foot utility easement on the survey. And that's not regulated by the zoning ordinance. That would be regulated by the utility that holds the easement. Exhibit number 9 is a photo of the front of the property. And that's the end of my questions, or the end of my presentation. You can let me know if you have any questions. And the applicant is also in attendance to answer any questions that you may have.
Okay, great. Before we go to the applicant, is there any questions for staff on the board?
I just want one clarification, Lisa, that the original permit was incorrect, but it said 3 feet from the property line, correct?
Correct.
But the applicant built a half a foot off the property line?
Yes.
So he didn't apply, he did not comply with the building permit.
Correct. Yeah, he did.
Okay, thank you.
Okay. Max, is the applicant here? I know
Yes,
you
the
said
applicant
that.
is in attendance.
Okay, I see him. Wayne Weiner. Good morning, Mr. Weiner. Am I pronouncing your name right?
Yes, sir, Werner.
Warner. Okay. All right, I'm gonna have to swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes, sir, I do.
Okay. All right, great. Do you have any documents that you presented in advance of today's meeting?
I do. I have all the documents that I received when I went to the permit office. And
Okay.
I can go over those now, or I can explain, I guess, why it seems so close to the property line, and that back wedge is because of the overhang of the building that I put up. There was a shed there prior to this, and when I went to the permit office, they told me to go ahead and use the back corner of that shed whenever I put this new, this new accessory building up. My mistake was that I didn't realize that that overhang on top, the drip edge on the top of the building would come into play. The utility line, we notified the utility company about the building before it went up, and they actually updated and moved the pole at that point in time. So they had moved the pole back and installed a higher pole at that time. They kind of, said, go ahead and do what you're doing. But I think my mistake is mainly that I did not keep in mind that there would be a drip edge on top of this building, and that puts it, definitely into that easement. And I apologize for any problem I'm causing you guys, but I kind of went with what they told me at the permit office. I think it was 23 or 24 foot tall and 3 foot from the property line.
Yes. Yeah. Okay, thank you. And yes, Wayne was sworn in. I just got a question in the chat. I don't know if that was from Mr. Sanchez, but yes, we did swear in the applicant. Mr. Winter, is that the conclusion of your presentation? Do you have anything else to add?
So I have other documentation that they had told me that it was a 3 foot from either side of from the side yard and from the rear yard. But as you see, my rear yard is like a pizza pie. And I don't know why I was under the impression that from the back corner of that building, that if I took a left, it would go to the side yard. And if I went at a 45-degree angle back towards the other property line where it's angled, I was well within that 3 foot compliance. I did not realize that that was also on an angle going back. So, that little pizza pie that I'm extending out is 20 some odd foot up, keep in mind, and is definitely, over that 3 foot variance. That's kind of my problem, is the very top of that building, that drip edge is going over that line. I totally, I'm not questioning that. I'm not contesting that at all. I'm just asking for your understanding on it. It's my first time doing something like this.
Okay. Well, thank you, Mr. Weiner. Warren, I'm sorry if I'm mispronouncing your last name.
That's all right.
Sorry about that.
That's all right.
Okay. Does the board have any questions for the applicant?
This is John Floyd. I have a couple questions. First, if I'm understanding you correctly, are you saying that let's say the walls of the structure are constructed more than 3 feet away from the property line, but it is just the overhang from the roof that is sticking out and cuts into that 3 foot area? Is that correct?
Is that for question to myself or to Lisa?
To you, Mr. Werner.
I believe if you, I believe so. Yes, if you look at the survey that I just got, I think it indicates that I am within that. Yes.
But it's just the overhang. It's not the, let's say, foundation or anything of it.
I am that ignorant about this because way up high, if you look at the overhang, it definitely sticks out, because I contested that with Lisa. I think that it says the overhang tie here on this image that she has up right now. That's what it, yeah, that's where the problem is as far as I can see.
And so have you done have you taken any look at what it would take to bring that, I mean, to essentially eliminate that overhang and at least bring it within compliance of the 3-foot requirement?
I really have not. I have not.
Okay.
I mean, I
Really
can
looking
certainly
at-
consider chopping the corner off of that overhang or something like that. I just thought it was a building that went along with everything else in the neighborhood, and I inadvertently did not, you know, like I say, it does stick out around the top of that building a little bit all the way up there. It's a little pizza pie in the sky that's over that line for sure.
I'd like to quickly clarify on the survey that I have pulled up. If you look on the left side, you can see that the building tie of the actual building to the property line is 1.7 feet at its closest point. The overhang encroaches up to 0.6, so that they say overhang tie to say the measure of the overhang to the building line, and they say building tie to measure the building to the property line. So just that little point of clarification there.
So Lisa, just to clarify, the actual building structure, not the overhang, is only 1.7. Is that correct?
So the structure does encroach into that 3 feet. It's
Okay.
1.7
Thank
feet
you.
from the property.
Any more questions for the applicant from the board? Okay. And does anybody from staff have any questions for the applicant? Okay. All right, if not, this concludes the presentation of evidence. The board will now begin deliberations. Just want to remind everyone that interested parties are not permitted to address the board during this portion of today's meeting, but you are permitted to remain present and listen quietly as the board discusses and votes. All right, members of the board, does anybody like to speak more in depth about this case? What are your thoughts before we move into a period of voting?
This is John Floyd. I'll just quickly give you my thoughts. I'm sympathetic to the homeowner. I recognize that zoning ordinances and things are complicated and people make mistakes. And unfortunately, this is a mistake that might require some, significant changes to that structure. But one thing I always come back to when we have these discussions is our job as a board is to apply 4 criteria. And if we can't find that those 4 criteria are met, then it is our obligation under the zoning ordinance to deny the variance. One of those criteria is that the issue is not something that a problem created by the owner. And I just don't see, even if we could find that the other 3 factors are met, I don't see how we could find that this was an issue not created by the owner. I mean, to his credit, Mr. Warner has said, I did this, it was an accident. And he's apologetic for it, and I appreciate that. But ultimately, we're not allowed to grant a variance in this case because he's the one that created the condition. And so, I mean, unless somebody has, other thoughts on how we get past that requirement, I don't know how I could do anything other than vote against the variance.
Okay. Mrs. Dryden, what are your thoughts?
I tend to agree with Mr. Floyd. I'm reading Mr. Warner's application, and he said, this is not my fault. But indeed, it is his fault. I mean, you can't, if the rules are the rules, you can't build something and then say, oh, well, I didn't know that, so forgive me and fix it. I mean, that might work sometimes, but I'm concerned because according to the records, the original building it still encroaches. So it's really not 3 feet off the property line. So it's not just the overhang that's the problem. It's part of the building. And I mean, I understand it's the first time you've done this, but that's why you have contractors and you have measuring tape and you figure this out. And if it said 3 feet, it means 3 feet. So like Mr. Floyd, I'm sympathetic, but I cannot with a clear conscience vote for this variance because I don't think we meet that criteria because it is the hardship was created by the owner of the property.
All right, Ms. Long?
I think both Mr. Floyd and Ms. Dryden summarized it exactly how I feel as well. So I would agree with both of them.
Okay. Mr. Williamson?
Hey, I had a question about item 22 on the findings of fact. It says there's a
Wait a minute.
5-foot utility easement. And then it says the easement is not regulated by the zoning ordinance, but it's under the jurisdiction of the utility that holds the easement. And so that leads to my question about the complaint that originated the.
Mr. Williamson, can you please speak up a little bit? Our court reporter is having some difficulty hearing.
Sorry about that. Can you hear me now?
A little bit. It sounds a little bit muffled, but we'll try to our best to make out what you're saying.
My question is relative to number 22 on the findings of facts, that there's a 5-foot utility easement that is not regulated by the zoning ordinance, but it's under the jurisdiction of the utility that holds the easement. And my question is, did the complaint come from a neighbor or from the utility that holds the easement?
Max and staff, did you get that? Were you able to hear what Ms. Williams was saying?
Yeah, we don't know exactly who made the complaint. I would assume it was probably a neighbor.
Okay.
Don't know for certain.
Okay. Ms. Williamson, do you have any other additional questions?
No, I tend to agree with John about the criteria that we are led to approve or disapprove.
Okay. And for me, I feel the same way as the rest of the board. I am very sympathetic when we have cases like this come before us. And Mr. Floyd, you're right. This always seems to come up, but we do have to follow what we were appointed and sworn to do. So I do feel the same way as my fellow board members. Okay, that ends our period of deliberation, and now we'll move into a period of voting. Is there a motion on the floor?
This is Dryden. I make a motion to deny this variance.
Okay, motion's been moved by Mrs. Dryden. Is there a second?
Long seconds the denial.
Okay, motion's been moved by Mrs. Dryden and seconded by Mrs. Long. Now we move into a period of voting. Ms. Long?
Long votes yes for the denial.
Okay. Mrs. Dryden?
Dryden votes yes to deny.
Okay. Mr. Floyd? John?
Sorry, I was on mute. Floyd votes yes to deny.
Okay. Mr. Williamson?
Williamson, yes to deny.
And Wilson, yes to deny. Okay. Now we're going to look at the findings, facts, and conclusions of law. I don't know if there's any changes that need to be made based upon the board's deliberation. I didn't see anything.
I didn't
Okay.
see anything either, so I make a motion to accept the finding of facts and conclusions of law as written.
Okay, there's been a motion by Mrs. Dryden. Now we move to, is there a second?
Long seconds.
Okay, motion's been moved by Mrs. Dryden, seconded by Mrs. Long. Now moving to a vote. Ms. Long?
Long yes.
Okay, Mrs. Dryden?
Dryden, yes.
Mr. Floyd?
Floyd, yes.
Mr. Williamson?
Williamson, yes.
Okay. All right, Wilson, yes. All right, next on our agenda is the approval of the July minutes. Max, were those sent out?
Yes, they were sent out with email about the meeting last week, I believe last Wednesday.
Okay, all right, great. Okay, is there a motion to approve the minutes, the July minutes?
This is Dryden. I make a motion to accept the minutes from the last meeting, the July meeting.
Okay, motion by Mr. Dryden to accept the minutes of the July meeting. Is there a second?
Second by John Floyd.
Okay, motion's been seconded by Mr. Floyd. Now we move into a vote. Mr. Floyd,
Floyd, yes.
Mr. Dryden,
Dryden, yes.
okay, Ms. Long,
Long, yes.
Mr. Williamson,
Williamson, yes.
okay, and Wilson, yes. Okay, July meetings have been approved. All right, under new business, we have the legal guidance for determination on appeals for historic district commissions, certificates of appropriateness. Max, I don't recall getting this. I may have missed it, but what is this about? Yeah.
It'll be a presentation by Miss Myers Sanchez. And
Oh,
Sanchez Myers.
sorry about that. I thought I was missing the document. Sorry.
No, and I believe we want to take about a 5-10 minute break before that presentation.
Sure thing. All right. So it's 10 o'clock. We'll come back at 10:05. Okay, do we have everybody back? I'm looking at the staff. I see there's some empty chairs there. But I don't know if we have to wait on those staff members to come back before Ms. Sanchez Myers gives her presentation.
It should only take a minute or so.
Okay.
Mr. Wilson.
Okay, looks like we have everybody back.
Oh, Mr. Wilson, I was just gonna ask, just because we have a court reporter here, and just to go ahead and maybe move the last agenda item up to now.
Okay.
And she'll leave because we need to vote for the vice chairperson, because now you are the chairperson since Patrick Welch left. And just so everyone knows, so it needs to be a regular member. And I believe currently John Floyd and Marshall Williamson are alternates right now. So the only two members that are in the meeting today that would then be able to be vice chair would be either Krista Long or Deborah Dryden. So that's just so everyone knows.
Okay. So Shad, how does this work again? Do we just do like any other vote motion on the floor? Somebody recommends a name and we vote for that person, et cetera?
Yes, just take the
Okay.
nominations and then we'll vote, or y'all will vote.
Okay.
Shad, who's been on the board longer, Miss Long or Miss Dryden?
I believe Miss Dryden.
That was my thought as well. I just wanted
Miss
to make sure.
Dryden, and I would actually was going to say, I think that she should be the vice chair just because I'm so much newer.
Okay.
So I'll second Miss Long's motion for Miss Dryden to be vice chair.
All right. So there was a motion by Mrs. Long and for Mrs. Dryden to be vice chair and seconded by Mr. Floyd. Now we will go for a roll call vote. And Shad, everybody who's been part of the case today can vote, correct?
Yes.
Okay, so I'll make sure. All right. All right, Mr. Floyd.
Yes.
All right, Mr. Williamson, excuse me.
Williamson, yes.
Okay, Miss Long.
Long, yes.
Miss Dryden.
Yes.
Mr. Wilson, yes. I'm calling myself Mr. Wilson, yes. Congratulations, Miss Dryden. I'm not sure if you want congratulations, but congratulate you
Thank you
anyway.
very much. I appreciate it.
All right. Yeah, I think both you and I have been kind of swept into these positions without, knowing, but it's okay. All right.
Learn as you go.
Yeah. Okay. So now just going back to our original agenda item, the legal guidance for determinations on appeals from historic district commission certificates of appropriateness is a very long title. Okay, Mrs. Sanchez Myers, we're ready for your presentation.
believe you're muted.
Yeah, oh, yes, Sanchez Myers, you are muted. Jill.
Am I unmuted?
Yeah, we can hear you now.
Okay, sorry.
Now you went back to being muted.
Okay. Can you hear me now?
Yeah, but you keep, for some reason, you keep muting, unmuting, and muting yourself. And it looks like your connection may be just maybe slightly choppy because you're kind of moving.
Okay.
All right.
I think I'm unmuted.
Okay, yep, we got you.
Sorry, my computer is really slow on WebEx, so it was about 3 steps behind me. Okay, give me 1 second. Sorry, I'm waiting on my computer to cooperate.
Fine.
Okay. Oops. Okay. So a big part of the Zoning Board of Adjustments role is to hear requests for variances. And those are the most frequent kind of hearings that the board conducts. But the board might also hear an appeal from a decision of a zoning administrator. And while it doesn't occur often, the ZBA is also designated by city ordinance to hear appeals from decisions of the Historic District Commission. So I just wanted to take a little bit of time today to provide y'all some background and guidance on ZBA's role in determining appeals from decisions of the Historic District Commission. So, okay. Lisa, you can go ahead. And this is just a quick overview of this little training presentation. I just wanted to start by giving a little bit of background on the historic districts in Charlotte and the Historic District Commission, and particularly discuss certificates of appropriateness, what are they, and what standards are used in issuing those. And then I'm going to go, we'll just kind of walk through some of the procedural aspects of Historic District Commission decisions and the appeal to the ZBA, what that looks like, and then talk about ZBA's role in reviewing the decision from the Historic District Commission, and specifically the standards of review that the board would apply, and then finally in making that decision. Okay, Lisa, next, please. So the city has designated 7 of its significant older neighborhoods as local historic districts, just in recognition of their importance in the history and character of the city. And per the city ordinance, the purpose of designating historic districts is to encourage the restoration, preservation, rehabilitation, and conservation of historically and architecturally significant areas, structures, buildings, sites, and their surroundings from potentially adverse influences, which may cause the decline, decay, or total destruction of important historical and architectural features within the city. So as a result, all construction in local historic districts, including alterations and additions, is subject to specially created guidelines that are applied by the Charlotte Historic District Commission. So next, please. So the city established a specialized commission, Historic District Commission, to address issues related to historic preservation and development. And there are 12 members in that commission. And by law, a majority of the members must have a demonstrated special interest, experience, or education in history, architecture, or other relevant disciplines. Currently, I believe there are 3 architects, some general contractors, home builders, real estate professional, landscape design, those types of professionals. And also by resolution of City Council, the Historic District Commission has representatives on the commission who own property, live in, or own businesses within the local historic district. So it is a very specialized commission. So as I mentioned before, all construction is subject to special guidelines that are applied by the Historic District Commission. So part of the HDC's role is to adopt principles and guidelines for these new construction projects. And then secondly, to review all proposed construction projects in the historic district to make sure that the project is compatible with the historic districts and the standards that have been established. So before a property owner can begin exterior construction in a historic district, the HDC must issue what's called a certificate of appropriateness. And that's basically a document that certifies the proposed project meets the standards that are outlined in state law and local ordinances and the local guidelines. So some minor projects can be approved by city staff for certificate of appropriateness, for example, fencing or driveways or shutters. But for major projects, those must be reviewed and approved by the Historic District Commission. And so that process is through quasi-judicial hearings to gather evidence and facts as to whether or not the proposed construction meets the standards and guidelines for that historic district. And so those hearings are conducted similar to evidentiary hearings of the Zoning Board of Adjustment. So after hearing the evidence, the HDC can either approve or deny the certificate of appropriateness, but the project can also be continued by the HDC for the applicant to conduct further study or rework their project, and that happens quite often actually. But the law requires that the HDC make a decision within 180 days of the application first being heard. So once that decision is made, any appeal of that decision to either grant or deny the certificate of appropriateness is heard before the zoning board, y'all. So next. So I wanted to just explain briefly how each project is evaluated. So projects are evaluated according to the City of Charlotte's Historic District Design Standards, which are based on and they incorporate the U.S. Department of Interior's standards for rehabilitation. So these design standards, it's actually, I don't know if you can see, but it's actually a pretty large booklet, probably 100 pages. So before issuing a certificate of appropriateness, the Historic District Commission must determine whether or not the proposed construction meets the standards and guidelines. And ultimately, the project must not be incongruous with the special character of the historic district. This is the key standard. This is a contextual standard, which gets its meaning from the total physical environment of the historic district. And the analysis of the special character of the district is incorporated into the design guidelines. We'll go to the next, please. So the Zoning Board of Appeals, when they hear an appeal from the Historic District Commission, is actually sitting like a court of appeals, not a trier of fact. So the board will be reviewing the decision that the HDC made, to ensure that it's supported by the evidence and the law. And so it's a little bit different from most of, our current hearings, in that the ZBA is receiving no new evidence. So there's no new testimony presented, and the ZBA is not determining new facts from the evidence. So they're using the facts that were found by the HDC from the evidence presented at that quasi judicial hearing. So the ZBA is essentially reviewing the record of the HDC hearing. So all the documents that were submitted to the commission and the transcript of all the testimony and the commissioner's discussion and deliberation. And so what the ZBA is reviewing that decision for any errors. And I'll discuss the different types of errors shortly, but mostly those are based on arguments of law. Next. So who can appeal the HDC's decision? So under historic district statutes, only an aggrieved party may appeal a decision granting or denying a certificate of appropriateness. So in legal terms, this is called standing. And that narrows the ability to appeal to those persons with a genuine grievance or someone that's personally injured by a statute or by a decision. So those who automatically have standing are the applicant for the certificate of appropriateness, and usually that is the property owner or their agent, and this is the most common type of appellant. But it could also be a person that leases or has a contract to buy the property in question. So if you have a property interest in the property in question, you also would have standing. Under the statute, the city has standing to appeal to the zoning board. So a neighborhood association, it could or could not. So if at least one individual member, say of a homeowners association, a formal association, if at least one member would have standing to appeal on their own, then that association would have standing. And then finally, a person who will suffer special damages as a result of the decision appealed has standing. So this is anyone else that's not the property owner or has a property interest, the city, or potentially neighborhood association would have to show special damages in order to be allowed to appeal the decision. Okay, next. So what are special damages? So the law requires that an appellant, in order to show special damages, an appellant must show that he or she has suffered damages distinct from those that are sustained by the general community, or some problem that is unique to a party as compared to the entire community. So in the context of land use, land development disputes, that often includes economic damages, such as a decrease in property value or other direct adverse effects on the property. I've just given some examples on the slide of some from case law that could be increased smoke or light, noise, or vandalism. But these have to be different from the effects of the project on the rest of the neighborhood. So I'll show you one example in the second bullet I have there. That's actually a Historic District Commission case. And in that case, a neighboring property owner was able to establish standing to appeal because she lived across the street from the proposed project, and the proposed height of the structure would have caused her a loss of her waterfront view and an estimated $100,000 property value loss. But I also wanted to note that one thing that is just not sufficient in and of itself to establish special damages is the location of the person's home. So the location of your home as a neighbor across the street or neighboring property owner does not in and of itself give a person standing to challenge the certificate of appropriateness. Also, insufficient would be just an allegation that new construction is incongruous or would harm the character of the neighborhood, or any general claims of a negative impact or a view of a building's not visually attractive. These are too general to establish that a neighbor would have or has had suffered any loss to the value of their property. Also, speculation about decreased property values. Well, this project, it's going to hurt the property values of our homes. That is insufficient according to the law. Next, please. So procedurally, what will happen when the board receives an appeal from Historic District Commission is that the ZBA will be provided the record on appeal. And again, that contains all the documents and evidence that HDC received at its hearing, including the transcript. And all ZBA members must review the entire record prior to the hearing. The parties or their attorneys may submit a memorandum of law to the ZBA a week prior to the hearing to help the board understand the issues, but that's not required. So at the hearing, the HDC will present first. That will be by the HDC's city attorney representing the Historic District Commission. And so currently that is actually me. So if there were a situation where I was representing the HDC in an appeal, then another city attorney, probably Thomas Powers, would serve as your advisor during the hearing. But the HDC will present first through their attorney, and then the appellant will present give their presentation. Again, usually this is the property owner or the applicant to the certificate of appropriateness, but if someone else has brought this appeal, then the property owner would also be provided the opportunity to present. Then the board would have the opportunity to ask any clarifying questions regarding the evidence or the law before deliberating and rendering its decision. Next, please. So generally, the appealing party's asserted errors will dictate the scope of your review. So an appellant may allege that the HDC committed errors of law, or maybe they violated statutory procedures or due process rights of a party, or that the decision was not supported by the evidence. So they might challenge one, or they might challenge, multiple or allege multiple errors. So how the ZBA evaluates these alleged errors, which is called the standard of review. So again, that's going to depend on the appealing party's asserted errors. And I'll talk about that next, please. So if the alleged error is that the HDC's decision was not supported by the evidence, or that the decision was arbitrary and capricious, then the board must apply the whole record test. So in the whole record test, the board will be examining the entire record of all of the proceedings to determine whether the HDC's decision is supported by competent and substantial evidence. And as a reminder, substantial evidence is evidence that which a reasonable mind might accept as adequate to support a conclusion. So if there's evidence in the record that would support the HDC's decision, then ZBA may not substitute its own judgment for that of the Historic District Commission. Okay. So what you're looking for is there evidence in the record to support their decision? And if so, the board is bound by that. And this is true even if the appealing party presented evidence which would support a contrary decision if you were to be making the decision yourself. So these are really key key facets here. So I hope I'm not confusing you. So you're reviewing for the entire record. Is there enough evidence to support? And if there is, then you're bound by that decision, even if there is evidence in the record which might support a contrary decision. So you have to remember, the HCC, just as when you are sitting in your quasi-judicial role, it's their job to determine the credibility of the witnesses and to weigh conflicting evidence and decide, which evidence they choose to believe. And so that requires deference to that board in making that decision. That requires your deference in that regard. Okay. Next. So if the alleged error was that an error of law that the HGC interpreted or applied an ordinance incorrectly, then the standard it's a different standard, and it's called de novo review. And that just means that ZBA considers the matter anew, and so reviews and applies the applicable law anew. So the ZBA should consider HDC's interpretation, but you're not bound by their interpretation or their conclusions of law. And the board may substitute its judgment as appropriate. So when considering interpretations of law, conclusions of law, the ZBA does make its own decision, and you're not bound by what the HGC, how they interpret it. So de novo review also applies to alleged violations of due process. And just as a reminder, what due process is, I know you probably hear that a lot, but due process is what ensures fairness in the hearing, making sure the parties had notice and opportunity to be heard, opportunity to inspect documents, offer testimony in support, and cross-examine witnesses, those kinds of things, protections. Next. So in an appeal, the burden is on the party who initiated the action. So it would be the appellant's burden to show that there was an error in the Historic District Commission's decision. Next. And so just wanted to quickly review, how much evidence is required to support the HGC's decision. Well, this is essentially the same as when the ZBA makes a decision in your quasi-judicial hearings. It's substantial, competent, and material evidence to support the findings of fact and the decision. So competent evidence is generally evidence that would be admissible in court, sworn testimony. Things that are not competent evidence, speculative opinions, which are unsupported or generalized fears, also non-expert testimony on matters such as property value or public safety. And then just a reminder that hearsay is not excluded, but it's given limited weight due to competency concerns. And the material means it's related to the standards that are applicable. Next. So if the appellant, so when it comes time for the board to make its decision, if the appellant failed to meet their burden to show that there was an error under applicable laws or standards, then the ZBA must affirm the Historic Districts Commission, Historic District Commission's decision to issue or deny the certificate of appropriateness. Conversely, the ZBA could reverse the decision. The ZBA could also remand, and that just means to send it back to the HCC and give them instructions to do something. So for example, if you were to find a procedural error, then the board could remand it for further proceedings to correct the procedural error. Or if the board determines there was substantial evidence in the record to support the decision, but maybe the HCC failed to make sufficient findings of fact, then the board could remand it for additional findings of fact. The board could come to a decision that's a combination of reversing and remanding. So if the board determined that the certificate of appropriateness was wrongfully issued or wrongfully denied, because the decision was not supported by substantial evidence in the record or was otherwise based on an error of law, then the board can reverse and remand it back to the HCC to either issue or to deny the certificate of appropriateness. Next. And that is all. Any questions?
Thank you, Ms. Sanchez-Myers. I guess the question that I would have, and I'm sure other board members may have some questions, is going back to the error of law, how would we determine that? Would you be in the hearing to help us determine whether or not if that is presented?
So absolutely, the board will, either myself or Thomas Powers or another city attorney, the board will absolutely have legal counsel to advise on the errors of law. And each party will more than likely submit a written, like a brief, a memorandum that will walk the board through the law and try to help you apply the facts to the law. But yes, absolutely, the board attorney will be there and available to advise.
And my other question before we go to the other board members, and this could just be semantics, but I guess my only concern is, could a resident who is living in one of these neighborhoods come before us with a regular case where they want to, us to approve a variance and use the fact, oh, I live in a historic district, so I see that the board may have approved another home based upon the historic nature of my house, approve me. Again, I know that's more, more hyperbole, but that came to my mind going this presentation. Yeah.
So I'm sorry, I'm not sure I'm clear on what your question is. I'm sorry, can you try to state that again?
Yeah, so I guess and again, this could be just something that may not come up, but if a resident lives in one of these neighborhoods and they want to approve, for the board to approve or deny a variance on their property, could they use the fact that they are in a historic district to their advantage based upon they may know that we are able to, approve cases, not approve cases, but I'm having a hard time explaining it, but I don't know if any of the board members can get what I'm trying to say. I'm just wondering if residents in these neighborhoods could use the historic value or nature of their home to their advantage based upon this.
So, and I don't see that as a particular concern. I'm not particularly concerned because when they're coming to the board for a variance, you're looking at the zoning requirements, and everyone is subject to the zoning requirements. If they want to do something special to their house because they're in a historic district, they have to get approval from the Historic District Commission under those guidelines. So they may go in front of both boards to get their project approved. I don't know if that answers or helps.
That does. It was one of those questions I had in my head, but it was just kind of hard to interpret it because, but yeah. Okay. Any other questions from the board?
I just have one. I'm just curious, how often does this come up, Ms. Sanchez Myers? I mean, is it, because I've been on the board for 1.5 years and I've, we've never even had a whiff of this. So does it come up occasionally or?
Yeah, to my knowledge, it has not come up very frequently. And I don't know if some of the zoning staff have any recollection of the last time this happened. I believe it's been a couple years.
Right.
But it is, per the ordinance, this is one of your roles and responsibilities. And, we may see one soon. So.
Well, I appreciate the presentation, and I think to Mr. Wilson's questions, it seems to me that the participants really have to present to us what they consider something that they didn't follow the procedure, they didn't follow the law. So it's not something that we have to cull ourselves. They're going to present the two sides, and we just have to look to see if what they're saying is indeed true. Is that kind of a correct statement?
Yes.
Okay.
Yes.
Okay. Thank you. I appreciate the presentation.
Amen.
This is Marshall. I had a quick question.
Yeah.
Jill, this is relative just to these 7 defined districts. Is that correct?
Yes.
And is there a location where these districts are clearly defined by a map?
Yes. So if you go to, and I meant to include the link on my presentation, to the city has on the city's website, there's a historic districts, there's a whole section, and there's the map, the guideline book that I was trying to show you. You probably can't see it. There's a link to that, but there is a whole lot of information on the city's website, including that map. And there's maps of each historic district. Yes.
Thank you.
Okay. And I don't know if you may have covered this, but would a case like this, if it does come up, would it be a separate agenda item during our monthly meeting, or would we have to have a special meeting specifically for a historically district neighborhood case?
Max or somebody can correct me if I'm wrong, but I believe it would just be on a regular agenda.
Okay.
Perhaps last, maybe, I don't know, but it's
Yeah.
to my knowledge.
Yeah, this is Shad. That's typically how it's been handled in the past. It's just added at the end of the agenda.
Okay. Great. Are there any other questions for Ms. Sanchez Myers? And thank you for the presentation too. It was really good. I just hope that these cases are little or small in nature coming before us, because I can see it being, kind of a grueling process. But anyway. Yeah.
Did y'all, if y'all want, I can send out a copy of my slides. I don't know if you got a copy, but if you want, I'm happy to send that out to all the board members if you would like. That's
Yeah,
helpful.
sure. I think that'll be helpful for the board, for us to kind of use that as a guide, and
I
looking
very
back in
much
case
like a copy, just
cases
at
come
least
up.
to put to put in my folder so that if it ever comes up, I can go back and refresh my memory about what we're supposed to do. I think that would be a good idea. Thank you.
Me too. Thanks.
Sure, I will do that.
Thank you. Okay, do we have any other items to discuss, Max? I think that's everything, right?
Nope, that was the last thing on the agenda.
I just want to say,
Okay.
Mr. Wilson, nice job today.
Oh, thank you very much. Thank you. It's
Absolutely. I
been a long
second that,
time.
Mr. Wilson. You did an excellent job for your first foray into the fire.
Thank you very much. I had some. I'm used to doing parliamentary procedure, but it's just a different language I've heard in these meetings as opposed to other organizations. So that's what you heard me say most on the floor. That's based on my, nonprofit dealings back in the day. So, but yeah, thank you very much for that. I really appreciate it. All right. So if there's no further business, hearing none.
I just want to remind
yeah.
Max, I will be gone for the September meeting. I'll be traveling out west. So I told them last month, but I just want to verify for everybody, I will be absent for our September meeting.
Okay. All right.
Thank you.
Great. Thanks a lot. Okay. All right. All right. Well, thank you very much, everybody. Our meeting is adjourned.
Thank you.
Bye-bye.
Thanks a lot. Bye-bye.